Hi everyone, how are you today? We are going to start our webinar on covenant enforcement, more specifically discussions on leasing and rentals and suspensions and fines. My name is Erum Kistemaker and I am the managing partner of Kistemaker Business Law Group. We are a boutique law firm that specializes in community association law, more specifically condominium and homeowners association law. And I welcome you today in joining us. As was stated in the description of this seminar, we will be providing to the CAMs that are attending this seminar today 2-hour elective credit that goes towards their CAM credits. So please do submit your registration information and your attendance information, so then we can supply the information to DBPR and provide you with your CU credits. With that, kind of how we're going to structure this so we don't have issues with the internet and don't have a good crisp webinar is once we start discussing the material, you are no longer going to see me, you will just hear my voice, so you can see the presentation materials, which will also be available for you after. A recording of the seminar will also be available for you after the seminar is over. I also think, just to keep things interesting, I will take questions after each section of the seminar. So we are first going to take the first sort of 10, 15 minutes to go over leasing and sale restrictions, and then I'll take questions. When we go over the fining section, then I'll take questions. I think it keeps it more interesting, and then people don't have to hold their questions till the end of the webinar. You can ask your questions by simply raising your hand. My assistant is sort of moderating this seminar, and she will see those that are asking questions, and I'll be able to answer them. Okay, with that, I am going to go ahead and move to the presentation and the slides. As stated, we're going to start with leasing and sale restrictions. I believe most condominiums and homeowners associations are facing issues with short-term rentals, transient rentals, Airbnbs, and VRBOs, and that's where the sales and leasing restrictions really come in, more specifically, the leasing restrictions. So I'm going to start with condominiums and how leasing and sales restrictions pertain in that situation. In condominiums, pursuant to 718-1045, essentially the law, Florida statutes, they do allow restrictions, but they must be reasonable restrictions when it comes to leasing and sales. Those restrictions also should be in your declaration. Restricting leasing and sales and putting those type of covenants, they really should be covenants. Those type of restrictions concerning transfer of property should really be in your declaration, which is your most important document for condominium associations and homeowners associations. You shouldn't have those type of restrictions per se in your rules and regulations, and those type of regulations and restrictions should not just be created by the board of directors, but should be voted on by your owners. The reasoning behind that is because unreasonable restraints are deemed unconstitutional and could be an unreasonable restraint on alienation. Alienation being every owner's ability to freely transfer their property. Therefore, a restrictive covenant, A restrictive covenant is a term, a promise, an obligation, an obligation not to do something that's contained in your declaration. The leasing and sales is not appropriate or proper or legal because it's not contained in your declaration. So it is very, very important for the boards and the managers when you're managing condominiums and homeowners associations to review with your lawyer your declaration to determine what are your leasing, sales, and transfer restrictions, and if you have any contained in your declaration for your specific community and association. Now, another thing is once you determine, okay, do you only allow long-term rentals? Do you allow short-term rentals, which are essentially 6 months to 30 days? Do you also allow transient rentals, which are 30 days and less? Well, then what restrictions do you have to approve that? And can you do background checks? Many associations just think you can freely do background checks, and that is not true. Although Florida courts recognize the right of an association to screen prospective purchasers and tenants, that right to do so has to be contained in your declaration. So if you do not have the right in your declaration to screen and approve tenants or new prospective purchasers, if that right is not in your deck, you cannot do it. So when you go to amend your documents, when you review your documents, and especially when you are making a charge and doing background checks, please check the declaration to make sure you have that right to do it. And if you don't, I believe it is, and you allow short-term, any kind of rentals, I think it's very important that you go to your lawyer and ask to try to amend your documents to get that right put in. As I stated, the most common screening procedure are background checks to ensure that the community is free from those who pose a threat to health, safety, and other residents. Now, obviously, that's the biggest concern with short-term rentals and transient rentals in communities is if somebody's just coming for a week, it's very difficult to get a background check or a screen on someone that's there for such a short time period. So just things to consider where, you know, oftentimes owners will say, well, we don't want you to restrict or, you know, how dare you review or have to approve who we're going to transfer our property to. But when you live in a community, especially in a condominium, those things become very, very important because you're basically sharing space, utilizing common areas with another person pretty intimately. The other thing that's very important aside from background checks is whether your declaration contains minimum lease durations and restrictions on the number of times an owner can lease in a given period. If your declaration contains minimum lease durations and restrictions on the number of times an owner can lease in a given period, I believe that that tends to discourage the number of transient residents. I am hopeful that most of your condominiums have similar language, but I will say I work with many condominiums that have no such minimum lease durations or how often an owner can lease in a given period, and essentially like allow all types of rentals in their condominium, and they're facing many issues due to that, especially a lot of our condominiums that are on the coast, because those are being utilized for short-term rentals quite often, which could turn a condominium almost into a condotel of sorts. Something that's very important in condominiums, but is a very stark distinction to homeowners association, is our section G here, which speaks to Florida statute 718-11-1013. Cams, please highlight that, underline that. Board members become familiar with that. That statutory amendment, because it was changed over the course of time, it's not a recent amendment, however, it is an amendment to 718-1110, it prohibits owners from renting their units, setting a minimum or maximum rental term, or limiting the number of times a unit can be rented during a period. So if you make an amendment, so those condominiums that I talked about that have no restrictions contained in their declaration with regards to the duration of leases or the number of times an owner can lease. And now a board comes to me, and it's a condominium, comes to me and says, well, listen, we want to amend our declaration, and we now want to put in reasonable restrictions, and we want them in our declaration because we went to your seminar and that's the way that you said to do it. Please be mindful that 718-11-1013 says that those amendments are only effective against owners who consent to the amendment and owners who acquire title after the effective date of the amendment. That means if an owner does not consent to that amendment is not applicable to them until they sell their unit to a new owner. I still say owners, try to put these restrictions in because some of the owners will vote for it because they want to preserve the safety, health, and wellness of the community. Of course, those that don't vote for it's not going to be applicable to, but at some point that unit is going to change hands and they are going to sell that unit, and then it would be applicable to the new people. However, that is a caveat and something that you must keep in mind. Furthermore, This is not applicable to homeowners associations. So we are encouraging all of our homeowners association clients to try to get those restrictions in the declaration now before Florida Statute 720 makes a change very similar to condominiums. Now is the time to put those restrictions in to limit Airbnbs, VRBOs, and transient rentals. So please get with your lawyers. If I represent you, please get with me so we can make those amendments to your HOA documents and possibly your condominium documents. Please note, Florida Statute 718.116 provides that if the declaration or bylaws provides for approval or disapproval rights, then an association may disapprove a proposed lease or sale if the unit owner if the unit owner is delinquent in payment of an assessment and you have the approval and disapproval rights in your declaration or bylaws, you are able to reject and disapprove a proposed lease if they are delinquent. So it is very important if you, in fact, are an association where you've got approval and disapproval rights. Again, those approval and disapproval rights need to be in your declaration. And if you have it and you have a delinquent owner, you can disapprove of that lease. So I also think that that's something you should really highlight, understand, and start enforcing, because especially in times like now, you may have a lot of delinquent owners. Now I'm going to discuss transfer fees. This comes up quite often. I get a lot of questions on this. What can we charge the owner for background checks? So, a pet deposit fee, any type of fee associated with simply transferring their property, whether it's by way of a sale or a lease. So please note, an association, both condo and HOA, may not make any charge in connection with a lease, mortgage, or transfer unless the association is required to approve the transfer and the fee is provided for in the governing documents. Now, here's a caveat. In HOAs, the governing documents are defined as your declaration, bylaws, article, and rules and regulations. Condominium, your governing documents are deck, bylaw, articles. It does not specifically provide and include as your governing documents your rules and regulations. That's kind of a little nuanced thing to know, but just kind of keep that in mind. Keep in mind, you can only do a transfer fee charge if, number one, in your declaration, it gives you the right to approve or disapprove a lease, and number two, it says you can charge a fee. Again, extremely important to go back to that deck and see what your rights are specifically. The association's rights are specifically with regards to leasing, sales, restrictions, and what authority the board actually has to charge certain fees. Also, once your documents say you have approval rights and can charge a fee, said fee cannot exceed $100 per applicant. Now, that $100 per applicant is specifically stated in the condominium docs, is not specifically stated in the homeowners association documents. However, if you go with a more conservative approach, it's better to sort of mimic what the condominiums do. However, some association attorneys will say, hey, well, because it doesn't specifically state it, it means that possibly homeowners associations could charge more than $100, but always in the statute it says a reasonable fee. So therefore, if we went and argued it in front of a judge, you're likely to get away with $100 because at least the condominium statute allows for $100, so at least that would be deemed reasonable. So if you're going to exceed the $100, I would not exceed it by very much with regards to these transfer fees, because it's sort of a highly litigated area. Another type of fee that you see quite often is, I am getting ready to rent. Can the association charge something to the tenant with regards to any potential damages that can be caused to the common area? The answer is yes, you can, if permitted by your declaration or bylaws. The association, both condominium and HOA, may require a tenant to place a security deposit into a separate escrow account maintained by the association in an amount not to exceed 1 month's rent. But it is extremely important to not commingle that money. And that security deposit is going to be treated like a security deposit is when you do a normal residential rental. And as you know, then those security deposits must go back to the tenant if there isn't something that's in excess of normal wear and tear. So, and it's important to maintain that in the escrow account the proper way. And who does the interest go to and who does the interest not go to? Does it sit in a non-bearing interest account? And then you've got to go to the statute that deals with that. That is why many managers don't take the security deposit, because there can be a lot of pitfalls with regards to maintaining it in an escrow account and making sure that you return it. However, the statute does allow you to charge that security deposit to get that money. And if associations can figure out how to do it, I think that is something good, because I'm seeing with a lot of short-term rentals and transient rentals, a lot of damage caused to common areas. And this may be a good way to recoup some money to further maintain or fix or repair common areas that were destroyed due to some specific renters. Disputes, as I stated, disputes regarding this deposit are governed by the Florida Residential Landlord Tenant Act. So if a manager is going to do this and the board is also going to charge this type of security deposit, I believe you need to go to an attorney who's also an association attorney and a real estate attorney that is familiar with the Florida Residential Landlord Tenant Act and become familiar with that act also. Please also note, managers, because you send out notices. Oftentimes I don't get these questions a lot, or we'll draft some of the documents, but we're not the ones that are actually mailing it out. It is very, very important to remember rules similar to leasing and sale restrictions, rules impacting the use of a unit or parcel require 14 days notice pursuant to both statutes. So if you're holding a board meeting, and at that board meeting, you're going to specifically state, hey, people can't play music at this volume after 10 p.m. That rule impacts the use of their specific unit or their parcel. Therefore, that board meeting whereby the board implemented or approved that rule and regulation concerning the unit or parcel, that's not a 48-hour notice of board meeting that gets posted. That would also need the requisite notice to all owners of that board meeting with a 14-day notice. So please keep that in mind. That is sort of violated quite often. Before we go on to the financing section, I would love to take some questions specifically on leasing and sale restrictions right now. Do we have any questions? Okay, well, if there's no questions, I'm going to go ahead and move to the fining section. CAMS, with regards to fining, 718.303 is the pertinent statute for condominiums, and Florida statute 720.305 is the Homeowners Association statute. And again, these materials will be available after the webinar, but just make sure that you have page 7 tab so you know the specific statute that is relevant with regards to fining for both condominiums and homeowners associations. We're going to start with condominiums. And again, once I finish this section, I'm going to specifically take questions with regards to finding. We are not taking questions at the end. I want to take questions when we're specifically speaking on each topic area. Condominiums. Provided that the governing documents allow the association with the ability to fine, the association may levy reasonable fine for unit owner, tenant, guest, or invitees failure to comply with the declaration, bylaws, or rules and regulations. The important thing in that paragraph and what needs to be underlined by the CAMs is provided the governing documents provide. So if your documents do not state that the association has the ability to fine, they're not going to be able to fine. So that does need to be somewhere in your governing documents. Again, in a condominium, your governing documents are your declaration, bylaws, articles, not your rules and regulations. So you're not going to get, the condominium cannot make a rule and regulation providing authority to fine. That authority to fine must be contained in the governing documents. However, you can fine a unit owner for not complying with the declaration, bylaws, and rules and regulations. So that's kind of an important distinction. Again, something that's important for UCAMs to review and have tabbed in their governing documents: leasing and sale restrictions, approval rights and disapproval rights, transfer fees, and now authority to fine. In a condominium, it is important to note a fine cannot exceed the sum of $100 per violation. The aggregate amount cannot exceed $1,000, which is number 4. Number 2, a fine cannot become a lien. That is extremely important to remember. And also remember, a fine is different than an assessment. A fine is different than a charge. Number 3, a fine may be levied by the board on the basis of each day of a continuing violation with a single 14-day notice and opportunity to be heard before a committee of at least 3 members. Your independent enforcement committee or fining committee, again, must be made up of 3 members. Those 3 members cannot be an officer or director, employee of the association, or the spouse, parent, child, brother, or sister of an officer, director, or an employee of the association. That is, number 3 is very important to remember, and in my opinion, is where the mess ups occur. So the board levies the fine. However, then you have to notice the owner that they're going to be fined and give them their opportunity to be heard in front of this independent enforcement committee. And then the independent enforcement committee is who approves or disapproves the fine. Again, 4, fine may not exceed $1,000 in the aggregate. 5, what I just said a second ago, the committee sole role, that independent committee that's made up of the 3 members who are not the board of directors, the committee's sole role is to determine whether to confirm or reject the proposed fine. Also, when a fine is imposed, once it's levied by the board of directors, approved by this independent committee, another written notice must go to the owner stating that the fine has been levied and how much it is and when it needs to be paid. And the fine must be paid within 5 days after the committee meeting. I'm going to take questions now with regards to fining. Could you tell me if there's any questions?
But Gary Thompson said, can we charge for questionnaire?
That's not, I want to take specific, so we'll hold those general questions to the end. I want to just kind of stay focused on these specific areas that we're discussing. So are there any questions with regards to condominium finding at this juncture? I'm actually very surprised that nobody has a question. Okay. Beverly, or she can type it into the chat. So Beverly, I believe you have a question. So my assistant is going to unmute you. Let's try this out and hopefully it works. So everybody can hear your question, or you can type it in so I can repeat the question. So Beverly, could you please ask your question? You're not muted. Okay, I'm gonna have to move forward. If you do have a question, please send it in writing. Is the aggregate of a $1,000 total amount of fines or per infraction? I don't know if the audience can hear you, and I'm not going to be able to repeat that. So where can I see the question? It's messed up. Okay, so the question is that aggregate of 1,000 total amount of fines or per infraction? It is the aggregate of that specific violation. So it can be 100 a day up to $1,000 per violation. Excuse me? Oh, okay. Another question. Can the board fine a specific amount like 1,000, or does it need to be like Can the board find a specific amount like 1,000, or does it need to be like and I can't read the rest of it. Okay, where's the questions? I'm sorry, the questions, we're still learning this. The questions are kind of confusing. No, that's not what I was reading. That's not the next one after the aggregate question. This is the question, and I can't read the whole question. That's the problem. Do you see what I'm saying?
Yeah, I see what you're saying.
Excuse me. Sorry, I figured it out. Can the board fine a specific amount like 1,000, or does it need to be like 1,000 a day up to 1,000? Are you asking about a condominium? I don't understand the question, but essentially condominiums are restricted to fining to 100 per violation, and per violation, the aggregate cannot exceed $1,000, period. Okay, another question, and I would assume, Beverly, your question is regards to HOAs. I've not gotten to the HOAs. I'm only going to speak specifically to condominiums right now. However, the question is, we only have 8 owners with respect to committee. Can owners in same unit serve on the committee? 3 of the units have some. Again, I think I need to, I'm going to just answer questions specific to finding right now. Marty, who is a CAM that I work with, your question is just $100. I'm not sure what the question is, if you could rewrite that. Liz, I'm reading your question now. What if someone wants to pay the fine to be able to continue a specific behavior that is not permitted? What is the next step? We would have to go get an injunction. They can't just keep paying the fine to keep violating the restrictions. remember, fining is just one technique and one of the ways to restrict someone's violation, but ultimately you get injunctions. These situations are arbitrated. They're stopped from doing it. You suspend their voting rights. You suspend their use rights. You fine them. But fining is just a piece of this puzzle to enforce your covenants and ultimately ensure that everybody's following your covenants and we stop the restrictive activity. So hopefully I answered that, Liz, but they can't just keep paying a fine to do a restrictive activity in an association. David, your question is, what happens if we have repeated offenses? Can we continue to levy fines up to $1,000 again for same owner? Yes, you can. But again, if the fining is not working and they're going to just keep paying that $1,000, that's why fining works really well in HOAs if their declarations are written well. Many condominiums don't even do fining because fining is kind of a pain in the butt. And it really, because of the restrictions on it and because it doesn't turn into a lien and because it can't go over $1,000, oftentimes is not the best way to restrain activity. It can become costly for the association. It's super regulated. It's very easy to mess up. So fining, again, is not your only way to stop and restrict behavior, and oftentimes is the most difficult way to do it. So if you have repeated offenses, you need to get to your lawyer and say, how do we stop this? And you need to consider suspending, suing, arbitrating, and all the other sort of options that I'm going to go into after we go through these fining questions. Terry, who are one of my clients, if our condo docs say we can fine and the owners must abide by the government ordinance, we are no rentals, can we fine owners who are renting less than 30 days? The answer is yes, if you follow all the rules regarding the fine. If they are in violation of the covenants contained in your governing documents, then yes, you can fine them. My questions refer to fines and condos. Beverly, I think you need to, I'm not sure what your question is. Here's your question, Beverly. Due to the short time frame for a fine to be paid received by the association, will email notifications be allowed to notify the owners? That depends. If the owner has agreed and opted in to receive electronic notice, then they can be notified by email. And I understand what you're saying with that short-term time to pay. That's why I believe those letters need to go out to the owners following that fining hearing meeting. But there could be a situation. So for instance, I haven't opted in my association to receive electronic notice. No, they cannot email me and say, hey, you must pay your fine within 5 days. I need to receive that notice. If an owner's not opted in to receive electronic notice, no, an email is not going to work for notice purposes. Marty, question. Can a condo fine at $1,000 immediately, or does it need to be? No, you're not going to get to the aggregate of $1,000 immediately because it's restricted in a condominium that it's $100 per violation. So how are you going to get there immediately? We can talk it through at another time, but I don't see where a condo on one violation is going to get to $1,000. Now that's different for HOAs, which I'm going to go into after I answer, and I'm only going to answer 2 more questions, and because I really need to get back, I believe, to the Homeowners Association fining. Helen Avery, what if owner refuses to pay fine? Owner refuses to pay fine, we file suit for damages, and then we get our attorney's fees and costs. Marie Kimball, again, a wonderful client of mine. Does the board have a set fining hearing committee Does the board have a set fining hearing committee, or is the committee created after the fine is issued? No, you got to create that committee in order to approve or disapprove the fine that was levied by the board of directors. So I think before you start fining, get that committee. Okay, wonderful, guys. And I'm so excited to see so many of my current managers that I work with on here and board members. I'm really proud of you for being on here and learning this. Thank you. Now, I don't know why my screen went right to suspensions. We've got to go over. Here it is. Homeowners Association fining. So just by raising your hands, and Jennifer, my lovely assistant, will tell me how many people raise their hand. How many managers do we have here today and board members that are specific to homeowners associations? Can everybody raise their hand? There's none? 2. Okay. 3. Fantastic. That's not bad. 3. How many managers and board members in the room both need to know this information for condos and homeowners associations? Please raise your hands. So quite a few. Okay, 8 to 10. So wonderful. So you poor managers that are sort of in the same situation as I, where we represent both condos and homeowners associations, I tell you, keep this sort of outline handy, have it tabbed. I have all kinds of checklists, cheat sheets. My associates have them. Jennifer will ultimately have them, because some of the things that we're talking about are so nuanced between condominium associations and homeowners association that it's very easy to forget the little nuances, but they are very important. So let's start with the first paragraph. Again, similar to condominium association, provided the governing documents provide the association with the ability to fine. The association may levy reasonable fines for a member, tenant, guest, or invitee, and based on their failure to comply with the declaration, bylaws, articles, or rules and regulations. So again, you've got to have that fining authority in your governing documents. Now, what's interesting in an homeowners association sort of scenario, and sometimes what we try to do from a practical standpoint, and I know of no case whereby this has been challenged yet. It was only 2 years ago or so that homeowners association in the statute, it sort of specifically included the rules and regulations as part of their governing documents. And now homeowners association, because the rules and regulations are specifically defined as their governing documents, now have that requirement to also record their rules and regulations. It's interesting because maybe that authority to fine could be in your rules and regulations. Now, generally speaking, most associations' board of directors can freely amend their rules and regulations. So that's sort of something more that needs to be decided by your legal counsel, but something that can be discussed is, can we put that authority to fine directly into your rules and regulations? Now, it can certainly be challenged because, listen, why should the board of directors be able to freely just give that authority to a homeowners association? Seems like something that the owner should vote on. But anyway, something to consider, and something that's nuanced from condominium association based on the definition and how broad that definition is of the term governing documents. Interesting one, a fine cannot exceed the sum of $100 per violation. Caveat with homeowners associations. Write this into the outline, unless otherwise stated in the governing document. So if you go to 72305, it will say, similar to the condominium document, that a fine cannot exceed the sum of $100 unless otherwise stated in the governing documents. Number 2, a fine may be levied by the board for each day of a continuing violation, thing, with that single 14 days notice and an opportunity to be heard before a committee. The committee is the same as the condominium committee. The committee cannot be made up of officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. A fine may not exceed $1,000 in the aggregate unless the governing documents provide otherwise. Again, in an association, as long as your documents say that the aggregate can be and exceed $1,000, then it can exceed $1,000. A fine, and then the statute specifically says that a fine under $1,000 may not become a lien. However, if your documents say that you can exceed $1,000 in the aggregate, guess what? You can lien. So there's a lot more authority and there's a lot more fear for the owners with regards to those fines, because if it exceeds $1,000, it becomes a lien on your property. When a fine is imposed, written notice of the same must be provided, similar to condo, and a fine must be paid within 5 days of that committee meeting. I'm just going to keep it on the side. Okay, so at this time, since we do have some participants that may have specific questions to Homeowners Association, I'd like to go ahead and take those. Thank you, Jennifer. Sorry that you have to keep, we keep tweaking these webinars. Okay, so which one is it? Marie Kimball? Thanks. No further questions. Okay, so nothing with regards to Homeowners Association finding. We are now going to get to suspensions. Please take note, suspensions for condominiums are discussed in 718-303, and suspensions are discussed for homeowners associations in 720-305. Both Florida statutes, and also remember, when you're fining, you should be suspending. I feel like these things should be done together. Also remember, the two most important suspensions of common area use rights, suspending their use of the common areas, and then suspending their voting rights. I think the most important things, I mean, I guess it depends on the community. If you've got awesome amenities and people really use those amenities, gosh, you sure wouldn't want to not be able to use the pool, the gym, and specific amenities. However, suspending owners' voting rights, I think, is something you wouldn't want to lose, especially if there was a controversial issue that was being voted on by the owners, and obviously the fines. So as I stated, both Florida Statute 718-303 and 720-305 provide for the association to suspend the voting rights of an owner or member due to non-payment of any fee, fine, or other monetary obligation. I hope everybody understands that. Any specific questions with regards to that specifically? So the association may suspend the voting rights of an owner or member due to the non-payment of any fee, fine, or other monetary obligation. So there were some questions before. Hey, what happens if somebody doesn't pay their fine? What do we do? And I said, look, everything kind of works in unison together. They don't pay a fine. They're delinquent on their assessments. They don't get to vote. Florida Statute 718-303 requires the delinquency. Now, here are the caveats with regards to suspending voting rights for non-payment of a monetary obligation. 718-303 for condominium states, the delinquency must be more than 90 days and in excess of $1,000. So it's not going to be for a single, one violation where the aggregate is just 1,000. So that's important to remember. It also requires that proof of the obligation to be provided to the owner 30 days before the suspension. So they're now 90 days delinquent. it exceeds $1,000, their obligation, their monetary obligation to the association, you still have to provide them notice before you suspend their voting rights. Very important to tab, missed all the time. People just think this is automatic. They owe us money, we get to suspend their voting rights. No, keep this tab, keep these nuances in mind. There is no requirement for a hearing prior to the suspension, but the suspension must occur at a properly noticed board meeting. So again, nuance, voting suspensions. You don't need a hearing like you do for other suspensions, and you don't need that hearing similar to the fining. However, you do need to give 30 days notice. It's got to be more than 90 days. It must exceed the $1,000 specific to condominium because it's 718, and that's it. But you got to remember those 3 prerequisites. The suspension ends upon full payment of all obligations due or overdue. Again, this is just with regards to condos. Now, in associations pursuant to 72305, specifically suspensions with regards to voting rights. 72305 requires only that the delinquency be more than 90 days. There's no that it must exceed the $1,000. There is no requirement for a hearing similar to the condo prior to the suspension, but the suspension must occur at a properly noticed board meeting. So the board still has to meet to suspend the voting right, but you don't have to have that additional 14-day hearing. Again, similar to the condo, the suspension ends upon full payment of all obligations due or overdue. 3, when a voting right is suspended, it reduces the total number of voting interests in the association. That is very important, CAMs, for our elections. Any kind of voting, this is very important to see who actually can and cannot vote and how we can reduce that. When a voting right is suspended, notification must be provided via mail or hand delivery. Again, the only exception I see to that is if they have opted in to receive electronic notice. Any specific questions with regards to suspension of voting rights? And the reason why I am taking the questions is it's so hard to go back after we've gone through the entire presentation to keep it straight with the condos, the HOAs, and all the different types of suspensions, fining, leasing, and rental regulations. So please ask your questions now with regards to suspension of voting rights. I'm just going to go to the last slide, but I'm going to give you guys like a minute to see if you've got a quick question. Okay. And I'm going to go to the next important type of suspension. Talking about condominiums, condominium suspension of common element use rights for failure to comply with the governing documents. Again, all the language, statutory language with regards to this is contained in 718-303. An association may suspend for a reasonable period of time, not endless period of time, reasonable period of time, the right of a unit owner or unit owner's tenant, guest, or invitee to use the common elements, common facilities, or any other association property for failure to comply with the declaration, bylaws, rules, regulations, and I don't know why I forgot to write it in, articles of incorporation. Important thing there is, yes, you can suspend it, but it's got to be for a reasonable period of time. Please get with your lawyers for the specific, what's considered reasonable and not considered reasonable. The suspension, number 1, the suspension does not apply to limited common elements of a specific unit. At this point, I think everyone who is attending this knows the difference between a common element and a limited common element. But just for a quick description, limited common elements, typically in a condominium scenario, are going to be like your balcony, typically it's going to be your balcony, your sort of patio, maybe your specific walkway, things that are outside of the interior of your unit, but are limited to your specific use or unit's use. Again, the suspension of the common area use rights is not applicable to limited common elements that are needed to access the unit, which is parking, use of elevators, guard gates, anything that could be interpreted as access to your unit. Utility services provided to the unit, and I believe utility services goes to cable, wireless, internet, all those type of things. Water, parking spaces, or elevators. Very important to remember. A suspension may be imposed with a single, so again, where the voting rights was a little dissimilar to the fining and you didn't need that single notice and the 14-day committee hearing, you just needed to have a board meeting. For suspending of use rights, you again are imposed with the obligation of the single 14-day notice and an opportunity to be heard before a committee, and that committee has to be made up of the same people for the fining. So what we advise our condominiums are when you're fining, you might as well go ahead and suspend the common use rights. And when you have the board meeting to levy and approve that suspension and the fining, if they meet the requisite elements, you need to go ahead and approve the suspension of the voting rights. Number 3. The committee's sole role, similar to the fining, is simply to determine whether to confirm or reject the proposed suspension. That's their only job. If the committee does not approve the proposed suspension by a majority vote, it's not imposed. When a suspension is imposed, written notice of the same must be provided by mail or hand delivery. Now, the previous slide, and I'll go back to the title of it, is Condominium Suspension of Use Rights for Failure to Comply with the Governing Documents. Now we're going into condominium suspension of common element use rights for non-payment of a monetary obligation. They're two different things. So let's go into the non-payment. If a unit owner is more than 90 days delinquent in paying a fee, fine, or other monetary obligation due to the association may suspend the right of the unit owner or the unit owner's occupant licensee, invitee, to use common elements, common facilities, or any other association property until the fee, fine, or other monetary obligation is paid in full. So, little less restricted than suspension of the voting rights, because there's no obligation that the $1,000 doesn't play into effect here. But simply by not paying their assessments or a fine, and if they haven't done so in 90 days, their use rights can be suspended. This subsection does not apply, obviously, to limited common elements, elevators, parking spaces, all of that. And the notice and hearing requirements do not apply. I still believe that the board needs to meet to suspend it. But what's also interesting, there's no 30-day notice requirement. So please go through your delinquencies. Who hasn't paid what? Because it's very likely you have owners that haven't paid a monetary obligation within 90 days. And guess what? They don't get to use the common elements. That's a very important one, and I don't think it's utilized enough. Any specific questions before I go into homeowners association suspension? I'm just going to give everybody a minute or so. Okay, doesn't seem like we've got any questions with regards to suspensions. Hopefully that means that my outline was fairly clear. Homeowners association suspensions. Please be familiar with 72305. Again, similar to a condominium, a homeowners association may suspend for a reasonable period of time a member, tenant, guest, invitee's right of the use of common areas for non-compliance with the governing documents. Again, the suspension does not apply to common areas that are used for access, very similar to condominium. You can't prohibit an owner or tenant from having vehicular or pedestrian ingress and egress. That is more important in a homeowner association perspective than it would be in a condo, and obviously parking. Same type of notice, that 14-day notice, similar to a condominium association. Everything else is the same as a condominium association. Homeowner association suspension for common area use for non-payment. It is also the same as a condominium. Any questions whatsoever on suspensions? Okay, now we're going to go into things outside of fining and suspending owners when they are violating your restrictions contained in your covenants. So some of those questions where they were saying, you know, they're not paying their fine, what do we do? They keep violating, the fines aren't working, what do we do? These are our options. First, I'm going to start with obligations of the board of directors. Obviously, there are covenants that are contained in your documents. We elect board of directors. Board of directors have fiduciary responsibilities and obligations to their members. One of them is enforcement obligations. It is the board that enforces these covenants. Therefore, enforcement obligation falls on the board of directors in exercise of its fiduciary duty. I believe that that's specifically contained in Florida Statute 718-1111 for Homeowners Association 723-031. Those speak specific to the fiduciary duty of the board of directors, as well as when we're associations and we're not for profit or for profit corporations, we also must adhere to, if we're not for profit, 617, and specific to fiduciary duty and obligation to enforce the enforcement, we look to 617-0830. There's also a specific third DCA case with regards to fiduciary duty and the enforcement obligation, and that's BJ Holdings Company v. Weiss. I know I have a couple association board members that are attending where we've got a specific issue that we're looking into with regards to what is the board's obligation for enforcement. I think you should go read 718-1111, BJ Holdings Company case for our discussions later on. While a board, this is important to remember, and CAMS for you to provide this information also and reiterate sort of my position to your boards. While a board may not ignore a covenant, the extent or degree of enforcement action is within the board's business judgment. There is some flexibility there, but the standards that the standard of the board for their decision making is what's called the business judgment rule, which is it's almost like a reasonable standard. What would someone do and what would be reasonable for that board to do in your position? So you simply can't ignore covenants, but what you do and how far you have to go is obviously each scenario is interpreted very different. There's different characteristics to each circumstance, and then the burden or the level or rationale that is used to determine if they breach their fiduciary duty is this business judgment rule. This is also important. I get the question on C all the time. Well, someone's saying we weren't enforcing such and such covenant, and now they're going to sue us individually. And I just went into detail with this with one of my boards this week, in fact. An action against an individual director where you get sued individually for failure to enforce a covenant where they're saying you breach your fiduciary duty, we're going to now sue you personally, that will only lie. It will only pass muster, and they will only be able to sue you where you can't provide any defenses and get that case dismissed if the facts demonstrate on the face of the complaint of the lawsuit that the director is guilty of fraud, self-dealing, or unjust enrichment. I also like to add criminal activity in there. The case that I believe is most pertinent to that is the case that I have cited there, but there's many, many cases. Furthermore, the obligation of a board to seek enforcement may be impacted by the language of the covenants relative to the specific community. Always important to read those documents and see what the obligation is. Many times, documents will be drafted in such a way where it'll say, the board of directors may enforce such and such covenant, but does not have the duty or obligation to do so. There's a lot more wiggle room when it says that, in my opinion, and many new attorneys for specific covenants, in order to protect their board of directors, are writing in that specific language. But many of the associations I deal with, I didn't draft their documents. It's very hard to get amendments through. They don't have a lot of time to give me to amend their documents. However, those type of things can be amended in your documents. I deal with a lot of condos with older documents, so they don't have some of that modern language contained in there. But that's also why we say, give us an opportunity when you're having a specific issue dealing with something. Let's try to come up with some amendment language and try to change that and modernize your documents. E, while covenants have a wide latitude under Florida law, they may not be unconstitutional or contrary to law. I hope everybody understands what that means. You can't have covenants that allow illegal activity. Your documents have to be compliant with federal, state, and local laws and ordinances, period. They can't contravene federal, state, and local law. Important thing to remember. I'm going to go into a little bit about what recorded covenants are and the importance of recording documents. So recorded covenants obviously are going to be primarily your declaration, any amendments to your declaration. Oftentimes I see condos and HOAs that don't have their bylaws recorded or their articles. Your declaration has to be recorded. I also think in the HOA scenario, as I said, there's an obligation to have your declaration, bylaws, articles, and rules and regulations recorded. Condo doesn't have that rule. Now, when you have these documents recorded, it's very hard for an owner to say, I didn't know, I didn't have that document. And at the time that an owner purchases and takes title to a unit, they take title to a unit subject to the recorded documents. That's also why your declaration has to be recorded. So A, properly adopted covenants or declaration restrictions are presumed valid. They're presumed valid because they're recorded covenants. Declaration, a covenant that is contained in your declaration does not necessarily have to be reasonable. That's why they say, try to get your covenants in your declaration. Once it's in there, that's a contract by and between the association and the owner. And because it's contained in your declaration, and because it's recorded, and because every owner has an opportunity to review that before purchasing, you don't have that reasonable test as you do when approving and drafting rules and regulations which are board approved, which must meet that reasonableness test. As I have stated, your recorded declaration is a contract between the owner and the association. view it as such. It is an agreement. You have agreed to those obligations, those restrictions. And it is something that attaches to your land. That's why we're able to foreclose on liens. It's similar to a mortgage. And from sale to sale to sale, because it attaches to the land and because it's recorded, it doesn't matter that it continues. It doesn't matter from sale to sale, owner to owner. It attaches to the land. It is part of the land. Those covenants, those restrictions, they're a part of the land. It's like a deed restriction. D, a declaration that is subject to amendment may change even if the change is to a provision on which a purchaser may have relied, which means every declaration has an amendment section. Every owner that purchases knows that these declarations, as long as you meet the requisite vote, can change. Therefore, they can't complain. With the exception of the leasing restrictions, they can't complain if the declaration's amendment and then say, hey, that's a breach of the contract. So that's also important. That's why amendments are so important, but owners vote on amendments. Again, only provisions that are arbitrary, against public policy, or unconstitutional will not be enforceable. These are with regards to those covenants contained in your declaration. In an HOA context, if a specific covenant is trying to be passed that doesn't fit your scheme of development, doesn't fit the look of your community, you cannot do that in an HOA context due to the fact that you're changing what people bought. So for instance, if people bought in a community that was a boating community and all the homes had docks, you could not pass an amendment to get rid of those docks because people bought into that community with docks. And that's what they mean about scheme of development. I doubt people have questions about that. I just kind of threw that in because I get a lot of questions about, is this a contract? What does running with the land mean? So I think some of that recorded covenant stuff could be a little bit complicated, but I'd like to just mention it. Now, more importantly, we're going to go over arbitration, mediation, what that means, when they have jurisdiction, when they don't have jurisdiction. And I'm sure, obviously, most of the people that are on this webinar have worked with lawyers because they have served on the boards and or are managers that deal with lawyers all the time. And I'm sure these are, the managers that are attending, they've been involved in some type of non-binding arbitration for the condominiums and or mediation with the homeowners associations. Again, the specific statutes to be familiar with for condominium 718-1255. And right now, because I don't believe I have any managers that deal with co-ops, I'm not going to go into 719. And mandatory non-binding arbitration, not applicable for HOAs except for elections and recalls. So I'm just going to start with bullet point A. Prior to the institution of any court litigation, a party to a dispute in a condominium scenario shall petition the Division of Florida Condominium Timeshare and Mobile Homes, which is the division, for non-binding arbitration, but only in certain circumstances. So for instance, if you have a dispute about breach of fiduciary duty of the board of directors, we're not going to go to arbitration. If you have a dispute over elections and recalls, 100% we're going to go to arbitration. But there are certain things that are non-arbitratable, which are breach of fiduciary duty, anything to do with assessments, anything to do with title, and another two areas. So it is important when you have a dispute, go to your lawyer so they can determine what is arbitrated and what's not arbitrated. Now, the reason why it's pertinent in this scenario is most covenant enforcement disputes are going to be arbitrated. That is a dispute for which the division has jurisdiction. So prior to instituting litigation, you must go through this non-binding arbitration with the division. You file a petition. The petition must recite and have attached thereto supporting proof that the petitioner gave the respondent, this is very important, this is missed all the time, advance written notice of the specific nature of the dispute. 2, a demand for relief and reasonable opportunity to comply or provide the relief. And 3, notice of the intention to file an arbitration petition or legal action in absence of a resolution of the dispute. So even prior to filing the petition, you must give notice to the violating party an opportunity to cure. And then you include in the petition that we gave this notice. Failure to include the allegations of proof of compliance with these prerequisites requires dismissal of the petition. Now remember, you're trying to get someone to comply with your documents. We have fined, we've done whatever we can. Now we're saying, hey, listen, we need them to stop doing X, Y, and Z. Well, before we can go and sue them, we got to go to arbitration. Before we can go to arbitration, we got to send that pre-notice. So oftentimes my clients get frustrated with me because they just think, hey, go directly there, or they think I'm trying to jack up the legal bill and, you know, say we got to go through this hoop and we got to go through that hoop. But now you're seeing, I mean, these hoops are specific in these statutes. D, section 718.12551, Florida statutes defines. So here's where the dispute kind of comes in, and the definition of what a dispute is. Defines the term dispute as any disagreement between 2 or more parties that involves the authority of the board of directors under 718 or association document. To require an owner to take or not take any action involving that owner's unit or the appurtenances thereto. So again, any dispute or disagreement between 2 or more parties that requires an owner to take or not take any action involving the owner's unit or the appurtenances thereto. Or 2, alter or to add to the common area or element. Furthermore, dispute is defined as any disagreement between 2 or more parties that involves a plan of termination. That's a condominium termination. To conduct elections and meetings meaning member meetings or board meetings, or give adequate notice of meetings or actions, and allow inspection of books and records. F, what I've been saying throughout this webinar. Although the Condominium Act does not define the term association document to include rules and regulations governing a community, the division does accept cases involving rules when the subject matter of the dispute falls under the statute. G, the condominium alternative dispute resolution provisions encourage but do not require dispute resolution through mediation. Essentially what that says is even once you file your petition, your arbitrator could say, hey, do you want to just go ahead and resolve this at mediation? The only issue with that is once you go to mediation, you don't resolve it at mediation, you can't go back to arbitration. So there are some pitfalls in agreeing to mediate. And mediation, sometimes there's no room for mediation because how are you going to concede with an owner when they're violating the covenant? It's an either or. They've got to stop it. So it doesn't, some things are not compromisable through mediation and are not fit for mediation. H, as I was discussing when we first started talking about this, that the division doesn't have general jurisdiction over every matter, and every matter does not have to go to pre-suit arbitration. So the disagreements not subject to arbitration, as I previously discussed, are issues dealing with title to any unit or common element. So any disputes with regards to parking. Typically, those are going to go straight to litigation. The interpretation or enforcement of any warranty, the levy of a fee or assessment. So we have a disagreement, condominium, levying of a special assessment. We're not going to go to pre-suit arbitration with the division. We go straight to lawsuit. Why we go straight to lawsuit with regards to foreclosures or damages claim for not paying assessment is because of C, the levying of a fee or assessment or the collection of an assessment levied against a party. The eviction or other removal of any tenant, because the associations in some circumstances have the right to evict a tenant, that would be litigated. That does not go to pre-suit mediation. As I stated, alleged breaches of fiduciary duty. The division's not going to arbitrate that. And claims for damages to a unit based upon the alleged failure of the association to maintain the common elements of condominium property. I'm not going to go through these miscellaneous cases with you guys. This is all sort of legal. I want you to read through this at your leisure. It's a lot of information, and it's really information I just want you to know, but it's very legal based. It's cases that I rely on so I don't mess up when I'm filing petitions for arbitration, when I send those letters. But really, all of that stuff your lawyer should be doing. I think if managers and board members get into some of this, that's the unlicensed practice of law. But I have provided it here as an informational tool for you guys. So do read through these miscellaneous cases. And I think that's all I have. Page, let me see what page that is. We don't have page numbers on here. 28, slide 28 does go over some defenses that can be made, and I do want to go over that. So what are owners going to say when we go to try to enforce these covenants, these restrictions? They're going to come and say, hey, if it's in a rule and regulation, or they may even try to say, hey, it's an unreasonable covenant, you can't enforce it. We're going to say, hey, go pound sand, because guess what? We know more than you, and we don't have to meet a reasonable test when it's a covenant in the declaration. However, if it's a rule and regulation that you're trying to enforce, the first offense is going to be, it's an unreasonable rule. And the test that's identified by the courts and the courts used in assessing whether an association rule or regulation, not covenant in the declaration, and whether it is valid is whether it contravenes an express or implied condition found in the declaration. So, your rules and regulations can't contravene any statement in your declaration. So if your declaration allows for it, your rule and regulation can't. And if they find that discrepancy in the documents, whereas this happens a lot with leasing, your rules and regulations are now going to start restricting the duration of leases and how often you can lease. However, you have none of those restrictions in your declaration. Someone could say, hey, it's unreasonable to put it in your rules and regulation, and in fact contravenes the declaration because we bought in this condominium because we thought we could do any type of rentals. So very important. The other standard to look to determine if it's reasonable is whether the rule reflects a reasoned decision-making, whether it is designed to accomplish its stated purpose. An association cannot adopt a rule and regulation which amends the declaration, and the board's rules and regulations are not entitled to a presumption of correctness. So again, don't try to use your rules and regulations as a mechanism to amend something that's contained in your declaration. And those reasonable, that it goes to a reasoned decision-making, really your rules and regulations should be regulating behavior that protects the health, safety, overall welfare of the community, and the peace and enjoyment of every owner's use of their unit and the common elements. Another defense is going to be waiver of the right to enforce a restrictive covenant. And I've discussed this with many managers and many condominium associations, that it's important to enforce it, because if you don't enforce it over a period of time, an owner can come in and say, you waived your ability to now enforce it. So, 2, waiver. The right to enforce a restrictive covenant may be lost by a waiver or acquiescence. Waiver is the intentional or voluntary relinquishment of a known right or conduct, which infers the relinquishment of a known right. The elements of waiver are the existence at the time of the waiver of a right, privilege, advantage, or benefit which may be waived, the actual constructive knowledge of the right. That is very important, because oftentimes boards don't even know that that covenant was contained in the declaration. The intention to relinquish the right. Waiver may be expressed or implied from conduct or acts that lead a party to believe a right has been waived. In the context of restrictive covenants, courts have stated that there must be a long, continued waiver or acquiescence in violation of the restrictive covenant for waiver to be found. Another defense, estoppel, selective enforcement, lashes. I think each one of you specifically read through these. You should be familiar with these defenses, but these are the typical defenses that are made by all owners and their lawyers. These are specific cases that I utilize, that I have looked at, read, try to defeat and or utilize when it comes to those defenses that we just went over. Waiver, estoppel, selective enforcement, unreasonable. Now we're going to touch on the difference between homeowners association disputes and condominiums. When it comes to covenant enforcement, those are not the type of disputes in homeowners associations that are arbitrated, because homeowners association, the division only has jurisdiction over HOAs for election and recall disputes, period. So in homeowners association, we must look to the very important 72311. And when you have a dispute similar to what we've been discussing all morning, you must send, after you fine, you suspended, things are still not going right, now we're going to want to sue. You have to send what's called a mandatory pre-suit, and I'm seeing a spelling error there, so excuse me, it's not a pre-suite, it is a pre-suit. And let me just catch that now. Will you make a note? Mandatory demand for pre-suit mediation pursuant to 72311. We like to call it the 311 letter. So whenever there's a dispute, you have to send a letter to the owner. This is what's going on. You have so long to cure it. We have the option to mediate it, and here are the mediators that we're going to mediate with. If they don't select to go to mediation, they don't answer that pre-suit mediation letter within 20 days, we file a lawsuit, they're not entitled to attorney's fees and costs. If the association gets a pre-suit mediation letter and doesn't comply and doesn't answer within the 20 days, doesn't select to go through mediation, and then a lawsuit is filed and they did not comply with that pre-suit mediation letter, the association, if it does not prevail, loses their rights to attorney's fees and costs. So it's very important, get with a lawyer if you've received this pre-suit mediation letter, because it's sort of nuanced, and it's very important when you end up in any litigation that you preserve the protection of your entitlement to those attorney's fees and costs. Disputes that are subject to the mandatory pre-suit mediation letter, specifically defined in 723.11.2, are the following. Those disputes between the association and parcel owner regarding the use of or changes to a parcel or the common areas, and other covenant enforcement, disputes between the association and an owner, any dispute regarding an amendment to the association documents, regarding a meeting of the board and the committees appointed by the board, any dispute between the association and the board, and membership meetings not including election meetings, and those related to the access of official books and records. Those are the disputes that you must send a pre-suit mediation letter for. Disputes not subject to pre-suit mediation and where you can go to litigation directly, similar to the condominium, collection of assessments, monetary obligations, any dispute subject to pre-suit mediation where you're asking for emergency relief, which is an injunction, or C, emergency relief or a temporary injunction. You don't go to pre-suit mediation. C, B just sort of reiterates what I just said. C, the statute requires that before filing a lawsuit, the aggrieved party, whether the HOA or the homeowner, send a written notice to the other party setting forth the nature of the dispute and requesting that the party agree to take part in the mediation conference. Again, what I just previously stated, what is contained in that 72311 pre-suit mediation letter. Furthermore, as I stated, the statutory pre-suit mediation letter will be compliant with 723.11.2a and must include a description of the specific nature of the dispute, to offer to participate in the process. 3, provide an explanation of the process, including that an attorney is not required at mediation. 4, however, that's only when the association is sending it to a member. The association needs to have counsel because they're a corporation. 4, a list of 5 certified mediators with their hourly rate, an agreement to pay half of the mediator's fee and to prepay that amount or make a deposit required by the mediator, an agreement to mediate acceptance form, and service to the last address on record with the association. Those things must be in the pre-suit mediation letter, or else you face a motion to dismiss if you file suit and you didn't comply with this, and you can lose your entitlement to attorney's fees and costs. Some other sort of nuances, again, stuff that you don't need to memorize. This really is more for the lawyers, but mediation must be scheduled within 90 days of the date of the offer. G, what I keep explaining, a party refusing to take part in the mediation or failing to respond to the request. Now, I think this is important for managers and board members because oftentimes you don't know the importance of going to the lawyer. And I've seen many associations just sort of ignore these pre-suit mediation letters that they get from owners, don't timely send it to the attorneys, which is why I think all the lawyers should be your registered agent, because lawyers, when sending the pre-suit mediation letter, will know to send it to the registered agent. You only have 20 days to respond. So G, highlight it, put a star next to it. A party, which can be the association, refusing to take part in the mediation or failing to respond to the request within 20 days provided in the statute will lose any claim it may have for attorney's fees and costs if it's the prevailing party in the ensuing lawsuit. This can be a substantial penalty. So just like it's important to respond to a complaint and ensure that the lawyer has enough time to respond to it, please don't sit on complaints and letters like this and send it to the lawyer on the 18th and 19th date. I can't tell you how often that happens. And if you're going to a good quality lawyer, we should already have our month filled, our week filled. It's very, very difficult. All of our associations require the requisite sort of attention and hand-holding. So it's very difficult to meet these deadlines when we're being notified on the 18th and 19th date more often, I get notified after the 20 days have expired, and I've got to go do some real finessing and figuring out how not to lose these rights. And sometimes you lose them, you lose them. So it's very important, and that can be considered breach of fiduciary duty by both the manager and the board members. So very important to remember. Again, I said this over and over again. Homeowner association elections and recall disputes are subject to 718-1255. So in that scenario, we're going to go to arbitration. Again, for your reading, you know, I don't know how interesting it is to read these cases. So it's certainly not for your reading pleasure, but could be some, I don't know, light bathroom reading or something. I've just added this for more for informational purposes. So with that said, we're ending a little early. I did still end at around 10:40. I'm happy to take some general questions if I can answer them, or some sort of important discussions. And again, thank you for attending. We are going to try to hold these every other month. I'm also doing another sort of interesting, what are we calling it? A webcast via Facebook, and we're trying to do that monthly. We call it BS and Bagels, and we have either property management company, banker, insurance brokers, relevant vendors come and speak. Last time we spoke about reserve studies and replacement cost valuations. We're going to hold one, I believe it's on October 14th. Please look out for our emails and our updates on our social media, Facebook, Twitter, Instagram, and also on our website. But I believe October 14th, we start it and do it from 8:30. We're going to start BS and Bagels sometime between 8:30 and 9, and it goes for about 45 minutes to an hour. And we're going to speak about condominium and homeowners elections, recalls, elections, and meetings during this pandemic, because I do think a second wave of the pandemic is going to occur. It was a little disheartening to see that President Trump was diagnosed and the First Lady today. So I do think it's still looming out there. I've seen a lot of my associations opening up their common elements, holding their board meetings, holding their elections. A lot of my associations locally do not have electronic voting at this juncture. So, you know, we're going to talk about that, how maybe you can still have the meeting electronically without having electronic voting by way of voting through proxies, and your written ballots much easier in a condominium scenario, not quite as easy in an HOA scenario because of the nominations of from the floor. But please attend that conversation. And again, utilize me for your legal assistance, my clients that are out there. If there are people that are not my client and are and are not my clients, you know, please learn more about myself and my firm. We are a boutique firm. I do have other associates that work for us, and we do specialize in condo and HOA law start to finish. And we do really try to promote educational seminars, educating board members, CAMs, because through education, I think we resolve a lot of disputes. So with that, I'm going to turn my camera back on so maybe we can see each other while I do the next question answer session. So just give me a moment. Can everybody see me? Okay. So I'm going to look over to some of these questions. They come through quite small. So where am I starting, Jennifer? Oh, can we charge for a questionnaire? Gary, what questionnaire are you talking about? Are you talking about the FAQ sheet? And no, I don't believe that you can. But be more specific about what questionnaire. And also, I just did some research on this. I don't believe HOAs have an FAQ sheet. Gary, is that right? more explanation with regards to that question. Another question we got from Kathy Killingsworth is, have a question on COVID. Right, Kathy, since you're my client and your manager actually wrote me on this, I'd like to, send you something specific offline. But generally, I actually had more questions, and I sent that to your manager. I want to know more details. I think you found out an owner has a renter that they know has COVID. What can be done? Again, you don't want to violate any HIPAA. You do need to keep certain things confidential when it comes to people's health. Do you know for sure that they were diagnosed? How are you hearing this? Is this hearsay? And are they still there? What was the level of exposure? I, the lawyer, anyone that's advising the association, in order to properly advise you, are going to need those specifics. Okay, Beverly, I think you're asking, I don't know if I answered this, but we have only 8 owners. With respect to committee, can owners in the same unit serve on the committee? 3 of the units have someone on the 3-person board. First, I would say we got to read the specific association's documents with regards to how the committee's composed. And then, you know what? I need to go back and look at the statute, Beverly. I don't know offhand the requirements with regards to the composition of the committees. It may be okay. And I'd have to go to because you said it was condo. I'd also look at the admin code specifically to committee composition. But I would start with your declaration on that. And no, I cannot answer that question without looking at your deck. And I too have to go back and specifically look at the statute and admin code on that. Sorry. Okay, James Cedarberg got a question. His question, is a board vote approved resolution? Is a board vote approved resolution effective as a rule? Okay, so to break that down, if the board has properly noticed a meeting whereby they're resolving a new rule or regulation, and the majority of the board votes for it, yes, that rule is then effective. Condominium, you don't then have to record that rule and regulation. HOA, you would have to record that. You should also notify your owners of any amendments to your rules and regulations, but you have to see, was the notice done properly, whereby the board met to approve this resolution? Did the board have quorum and hold the meeting properly? Was a proper motion made and then it was approved properly? So there's sort of steps to it. It's not just like, hey, the board voted and approved a resolution. You got to look at notice, quorum, so on and so forth. I think you go on to say something about, we have written HOA fee checks from owners that date back many years. Should the board, I'm not going to answer questions that are specific. If I'm not your attorney, which James, I don't believe I'm your association's attorney, and sometimes I feel uncomfortable answering some of these questions because of attorney-client privilege, but some of these questions I can't answer in a general form, and I do really need your documents. If you, James, you guys need to talk to counsel with regards to that specific question about shredding of checks. Beverly Grissom, you have a lot of questions with regards to your condo, Beverly. You need to make sure you've got good, competent counsel again for that condominium. But your question is, regarding condos and the fines committee, can 2 owners in the same unit serve on the committee? Beverly, please go back and tab where we said who can serve on the committee. It's not so much about 2 people that live, there's no restriction with 2 people in the same household unless they are the spouse, child of that person. So go back and please look at that. And again, when specifically sort of making these type of determinations, I think that you need to go to a lawyer because it is interpreting the Florida statutes, and interpretation of the Florida statutes, you want a lawyer doing that. And then Gary, I'm not sure, I do want to try to at least answer your question, but it just says lender. So with that, again, Beverly, just go back and read this section for condominium of who comprises the independent committee, which it can't be any board members, directors, officers, employees of the association, or anybody related to the board of directors and officers. You've got a very interesting question, and I do think you should get a written opinion before you make any decision with regards to that. And, it's interesting, just because you have such a small association, you only have 8 units. And obviously you want to have this independent committee. So look to the statute once again, but I don't think there's a restriction on if you live in the same unit. It's more if you are the spouse, child, or relative. It doesn't say if you're roommates. But again, I think council should specifically look at that and give a more specific opinion to your association. You may have something in your declaration that further defines your committee makeup, and maybe in your documents it says a committee can't have 2 persons that live together on a committee. Well, it's 10:47. I do have some more time, but I don't see any more questions coming in. Also, what I'd love to see is when you guys do send back your information sheet and your registration form and your attendance form, please give us ideas of what else you would like these webinars on. In the next few months, we are going to focus on our HOA and condominium board certification, and we'll probably start that in November. Please note, CAMs and board members, every HOA board member and condominium board member needs to attend a board certification and present that certification so as to show that they're certified to serve on the board, and they must do that within 90 days of being elected. So I know a lot of elections are starting for my condominiums this month. So we're going to try to have a HOA and condo board certification meeting towards the end of November, beginning of December, and squeeze those in between Thanksgiving or maybe before Thanksgiving and just before the holidays get sort of crazy. Please send us in suggestions of what else you would like webinars on. I love to do these. I hope that they're working out, and I think they're nice over the web. I did get one more question from Terry. We have nothing in our docs about pets, so we cannot restrict who can or cannot have pets. However, can we make a rule reg that pets are not allowed in common areas? I'd have to look at your documents. That's a great question. We have nothing in our docs about pets. That means that you allow pets. So no, I think you can restrict a little bit how the pets use the common areas, because there's other safety issues with regards to elevators, and certainly you can restrict. They need to be on a leash. They can't get within this many feet of the pool. So yes, I believe that there are certain restrictions that you can put in your rules and regulations with regards to pets in your scenario. Terry. However, I do not believe that you can have a rule that just eliminates pets in your common areas. And also then remember the scenarios with regards to emotional support animals and disability animals, service dogs. And last question I'm going to take is from Gary Thompson. Board of directors, can they gather for community events and not be considered a meeting? If all of the board are direct, I think then you would define it as a social event where other members would be attending. So if other members are also there and the board of directors are there, I don't think it would be considered a meeting. Now, if it was quote unquote a social event and all the members were at it at the pool, I think you should try to avoid that. or you need to ensure that they're not talking about association business. They're obviously going to. Just make sure that they're certainly not making any decisions or voting on anything. If all of the board of directors or a quorum of the board of directors are all together and they are voting and discussing how they're gonna vote with regards to a specific issue, then that, yes, is a meeting. But remember, board of directors can now email and have discussion that way on certain issues where it's not considered a meeting. Okay, I will take another question because I love Marie Kimball. Off topic, but how are associations handling membership meetings proxies? Do you specifically mean, Marie, and will you just write back yes or no because of COVID? Let me see her response. Okay, with regards to COVID, what we have been, if you don't have electronic voting in place, we could have multiple Zoom rooms, try to have an election whereby we encourage owners to attend electronically through Zoom. Condominium a lot easier because they send in their written ballots, they send in their proxies. We do a lot, we know we can get quorum doesn't really play into effect. It only plays into effect to have the meeting. We don't need to have quorum for the election. We look at their ballots, count their ballots. But we would have to have one person or two people somewhere in person, potentially have another room that's being watched where they're counting the ballots. And then the owners, as long as they've mailed in their items, I think we can achieve having the vote whereby they don't have to attend in person through Zoom in a condominium. I think it's a little harder in an HOA, but I do think there would have to be the committee that's counting the ballots in person. So at least 3 people may have to be in a room all together, but I think there may be a way to socially distance them. That's at least how we've been at least trying these annual meetings and the elections in a condominium scenario. The reason why it gets harder in an HOA is some HOAs still allow for nominations from the floor, and I'm still trying to think through that because you may be able to still do nominations from the floor via Zoom. The problem is the mailing of the ballots. So it's a lot easier to do nominations from the floor when you're all in person because it gives the person the ability to then vote for that person that just nominated themselves. But I don't know how I would do that voting per se in an HOA with the nominations from the floor because the proxy would have already been prepared, the limited proxy, how you want your proxy to vote that's attending the meeting on your behalf. Or if they allow for written ballots, that ballot would have already been sent back. But Condo, talk to me about it. I think we are trying to do those through Zoom and just have 3 people or the people that are counting the ballots meet in person and say that that's where the meeting's being held and encourage all the owners to attend via Zoom. All right, well, thank you, everybody. And again, the name of my firm is Kistemaker Business Law Group, and I am going to go to our last slide with some information with regards to the firm. Thank you very much. Have a good day.